name's Ray Colleen, and I know a couple people at EFF, and they approached me about bringing EFF into Google to talk. And so I worked it out, and they were very gracious to bring down both Danny O'Brien and Jason Schultz, who are going to talk a lot about EFF. So I'm going to turn it over to them.
Thank you. This is a classic situation of me promising to give away lots of secrets, and then Google making those secrets available to the world. If only I'd put some robots.txt at the beginning of this, it would have been a lot safer, I think. My name's Danny O'Brien. This is Jason Schultz. Jason's a real lawyer for the Electronic Frontier Foundation. I basically play one on TV. My background is that I was a journalist and used to give a lot of talks on these issues. I'm officially the activism coordinator for the EFF. I started, I guess, in May. And one of the things that I found kind of fascinating was going in was that I think, like most people, I had a kind of folk subconscious idea of what the EFF did. And with no real specific details, because I'd never really kind of inquired into it. And once you're in the EFF, you realize that a lot of people, again, have a general idea that, you know, this is an organization that works for good, not evil. They put them in the right category there. But we often get a lot of requests that don't quite fit into what we're doing. And, you know, people often ask the Electronic Frontier Foundation to do, you know, there's a lot of stuff where we get emails saying, well, you know, somebody will post something to Slashdot and they'll say, well, why isn't the EFF there with their, I know, their tanks? Why aren't they marching on Washington? And we have to explain that we're primarily a public interest legal group rather than a paramilitary outfit. So I was kind of curious, given that we're in the press so much, why most people don't know about the true situation. I think this is actually parallels you guys in a lot of ways. In that, you know, there's a lot of things that, generally speaking, we'd love to talk about. And, you know, I'm happy to share with you now. And, yeah, if the NSA wants to pop along, you know, just put the little chit through the door and listen in. It's nice that we've got the video link there, so they can just record that later. We don't usually speak about the mechanics of the Electronic Frontier Foundation for a few reasons. One is oddly, we don't want to be the story, or indeed the clients. As I'll explain later, we're a very interesting hybrid of a legal firm with a technology outfit with an advocacy unit. One of the rules that comes across from the lawyers is you always want to concentrate on the client. And on the advocacy side of things, we really want to get across the issues rather than have our name necessarily attached to everything. Again, because we're a legal firm, we have very serious legal obligations. We have attorney-client privilege. We have to be very careful about what we say about current and ongoing cases, and also about cases that we've settled or dealt with in the past. There's one of the things that definitely affects us is that while we are a public interest legal group, when we represent clients, and we put aside any of those considerations because the most important thing is to win the case of the client. If you imagine this is sort of a fire and forget policy, we talk very carefully about what we're going to do before we get involved in a case, but the moment that we accept that case, we're working for one person. And in a lot of cases, us talking about other issues may affect that case. We are big fans of free speech, and that sometimes can be used against us. There are definitely attempts when we go into a legal case for people to try on the idea that the Electronic Frontier Foundation, I don't know, will suddenly take all the legal documents and start file sharing them. Or you know, broadcast them to the moon or something. And this isn't the case, clearly. But it's a legal tactic that we want to try and avoid. So generally speaking, we don't make a big song and dance about what we do and how we do it. You know, classic example of this, I don't know whether many of you know, but one of our founders was John Perry Barlow. And he wrote a thing called the Declaration of Independence of Cyberspace. Which, you know, among many things says that, you know, people in cyberspace aren't bound by the laws of you puny, fleshy earthlings, which is a hard case to argue for in a court of law. We have to emphasize we don't see that as a legally binding document. Okay, so I want to tell you some secrets. So obviously the best way of doing that is by reversing our usual rules here. We've just generally taken out a lot of the lessons we've learned from normal standard EULAs. So by looking, glancing, or thinking about this slide, good, that's all of you. And for the people in Atlanta, even thinking about the idea of this slide actually agrees that you won't tell these things that we're about to tell you. Also, I think me and Jason's names are common law trademarks now, so you can't use those in any conversation, or reverse engineer our brains, or put this onto a CD or MP3, or even just stick to these existing conditions, because if you try and do anything that doesn't fit in with these, we reserve the right to change them. That's actually cut and pasted. The last bit there, which you probably can't see, is cut and pasted from the iTunes contract, which basically says what we say now may change, and you will still have to obey Steve Jobs, look into the spinning mirrors. Okay, so once we've got through the secrets, this is how the EFF really works. This is actually the thing that we have on the table in our conference room. See, this is exactly what the MPA thinks we get up to. We just have this little thing. We do make a lot of decisions in that particular room, because that's where all of the different groups within the EFF meet and come up with policy. We determine our cases and we determine what we say, basically by looking at what we think is going to affect civil liberties and how we think we can transform and strengthen civil liberties using technology. As I said, we're kind of an odd organization. This is due to 15 years of hybridization, spelled Englishly, so I can't pronounce it. The original rule was defending freedom in a digital world. That's 15 years ago. The original intent was to be a foundation. John Gilmore, Mitch Kapoor, John Perry Barlow, and others pulled their money together, and the idea is they'd give this money to organizations that they felt would understand technology, would understand the issues of civil liberties, and would understand the law, and would go out and bind those together so we wouldn't lose any fundamental freedoms. Turns out there wasn't anybody. And that was the first stage of the Electronic Frontier Foundation, where we went from being a foundation to trying to work out exactly what an organization like that would be like. That went through various different phases. Initially, it was defending cases, because that was the most pressing and timely thing. Then we went through a phase of trying to influence policy in Washington, directly by lobbying and trying to build coalitions of tech companies to achieve those ends. Ultimately, we found that that was very unsatisfying from the point of view of actually defending civil liberties, because you're dealing with so many vested interests, and when nobody understands what you're talking about and why you're there, you find you have to do an educational process. You have to bring people back up to speed. About 5 years ago, we switched much more strongly back to doing litigation. And I think that was probably because as the technology began to establish itself, it became clear that those who didn't understand the issues were not only waking up to them, but beginning to react in very traditional ways, which is using large power groups, mentioned no names here, but they end in AA, moving in to prevent the freedoms that these technologies were providing or enhancing, and using their weight in government and in regulation to stop that. And what that meant is we went back to the courts in a lot of cases. We went back to the courts, we went back to the standards committees, and in 2000 we built up again a primarily legal team, a large legal team to pursue litigation, and also to try and represent the people that clearly weren't being represented in these areas. With what? With money. Just to give you an idea of the size and how this thing works, our current budget is, and this is kind of a secret, I'm revealing this for the first time because we haven't filed yet. This is around 2.5 million. We have 23 employees that are funded with that, and a third of those are returners. So that's a pretty efficient ratio. A lot of our money goes on people, all of whom work on projects. The actual sources of our funding are kind of odd for a non-profit. We are a non-profit, but rather than the usual construction, which is taking money from foundations that sponsor worthy causes, or often companies or corporations. Almost 75% of our budget comes from individual donations. We don't take government money. Corporate money tends to be earmarked for specific events or projects, which we like, because that gives us the freedom to criticize the corporations that we work with if we felt that was necessary. We don't feel like we're developing obligations with them, and they like it because they don't have to explain why they're funding everything else we do. We have 10,000 very independent members, and because those are the people that we take our money primarily from, we listen to them a great deal. And really, when we're not representing clients, those are the people that we're representing. So in fact, almost the most important job, I'd say, on a day-to-day basis at the Electronic Frontier Foundation is what's the intake person. Because there's one person who answers all the incoming emails, fends off the phone calls, and directs them to the right people. That's how we often find out about cases that we really should be defending. It's often how we find out about new technology and new effects. And oh look, it's me. I'm tempted to do the mirroring effect where I hold it up, but I won't. It's also how we find out what people are concerned with. Very often we'll get an issue sent in by a member, or even someone who just wants to know our opinion, and we'll form our policy based on that. Okay, more secrets. This is our secret internal structure. Are we back? Yes. Much less secret now. The illegal, that's a term of art amongst lawyers, apparently. This is the secret sacred pyramid of the EFF. We do a lot of tech research, which unusual for a law firm. We do things like work on anonymizing systems, analyze printer dots. We study trusted computing and write white papers on that. We also support and work on projects like GNU Radio, the software radio, and also Myth TV. This is useful because it enables us to keep ahead of what's going on. It's also useful because it gives us, again, more purchase in these things. For instance, one of the roles that people probably don't know about the EFF is we actually represent Myth TV and GNU Radio on standards bodies. Because we try to, and in fact it was Cory Doctorow who spent some of the time doing that. We fund the appearance on the standards bodies, and we argue in those cases where people would normally not be considering exactly what the impact of, say, off the top of my head, the broadcast flag might do to open source development. So having a tech side enables us to do that. And you know, if anybody wants dares cracked or rewarded for a prime number, we also do that too. The legal side, I think I'll probably leave to Jason to go through exactly what that is. The illegal side is the rest of us. And what we do is advocacy and press and lobbying representatives to the extent that we can. Because of the way that a 501c3 organization works, we can only lobby them 20% of our time. And so I'm kind of that 20%. And also we publicize things. It's very odd, having been a journalist, to suddenly be often the, in the best situations, the unique source of information for the press and the public. And in the times where we're probably doing the most good is when we're the second source. It's incredible how important it is when somebody's writing something based on what the MPAA or the RAA are saying, that they have someone else to call who'll give them a confident, grounded in technology reason why those people are on crack. So that's what we do. That's what the illegal side does. And this sort of central pyramid, this kind of eye in the middle, is where we decide what those policies are. And I won't spend too much time talking about that, because I think that's something that we can go over in the question and answer session. But that's basically where those things emerge. The other thing that's happened over time, which is something that people I don't think know about, is that we're no longer the only people working in this sphere, which means that we can really concentrate on tech research and litigation and grassroots advocacy. Over time, over the 15 years that we've existed, other groups have taken up issues that, really deserve to have other resources thrown at them, and we work with all of them. Free Software Foundation, Public Knowledge is a great advocacy group that work in Washington that complement us very well because they're there fighting that fight. And also we'll often team up with universities and indeed Google in an indirect way with projects like Chilling Effects, which, as you probably know, is where we put up the DMCA takedown notices that end up being removed from Google's search engine, so that people have an objective third-party way of discovering exactly what's going on. So we work with a lot of people now, and that's great, and that allows us to concentrate on what we really like doing, which is getting Jason out in public to explain what we really do. Okay, Jason.
Okay. Okay, so my name is Jason Schultz. I'm one of the staff attorneys at EFF on the legal side. Just to give you a little bit of background on kind of how we're structured there, we have 9 attorneys, and we focus, I mean, each of us do a little bit of each piece of each case, but we focus sort of in these 3 different areas, one of which is sort of classic First Amendment rights. So websites that people try and take down or the government tries to shut down, or someone who's trying to publish something on the internet, exercise their free speech rights, First Amendment rights. We have attorneys who specialize in that. We also have attorneys who specialize in sort of classic privacy, government surveillance, a lot of the stuff going on with the NSA wiretapping and the associated stuff with that, which I'll talk about in one of our lawsuits. That's sort of one area as well. So we sort of put that together, the free speech and the privacy together, as sort of traditional civil liberties. The second area is intellectual property, and as you're all probably aware on some level or another, it's become quite a contentious issue, more so than I think even 5 years ago. Not just in terms of downloading music or movies, but also just in terms of users and consumers' ability to use the media that they have actually purchased, right? The ability to space shift or time shift your media from one screen to another, from one device to another, to have someone host it for you, to gather up information on it, to post screenshots or other things to your website, to put up a fan site, to write fan fiction, to do all of these things, to create your own characters in an online gaming world that might resemble, say, a comic book character or a movie character that you really are into, that you identify with. All these issues are starting to become more and more prevalent in battles in the online world, in the technology world. We've also recently launched a patent busting project, which I'll talk a little bit about too, because patents are becoming more of an issue outside of even the corporate technology space. So we have a whole intellectual property kind of fair use consumer rights side as well. And then we have also a lawyer who's working on electronic voting. So even before the last election, electronic voting was an issue about whether these machines actually work the way that people say they do. Can we verify the code? Who can see the code? How do we know if they're changing the results? Things like that. So it's another little aspect of what we do on the legal team. One other thing I wanted to say is about the intake. We do get a ton of phone calls and emails and people writing us either because they've heard of a case or they have a case or they're in trouble. And that's actually something that we're really proud that we do. Oftentimes we can't get back to everybody, but it is one of the things that really kind of keeps us in touch with what people need. And it is often the source of the cases that we end up defending or bringing, is that we'll hear a lot of complaints. So it's a good meter, especially for members. So for any of you who have joined and who are members, we really do try and listen to the things that you're concerned about, and especially if you know of cases that we should take or issues that we should take on. I will say this, though, that we don't have the resources, unfortunately, to help out everybody. So what we end up doing in terms of picking our cases is we'll often look for the ones that can maybe have a broader impact. So you'll sort of see a trend, hopefully, in the kind of legal cases we bring, where it's not, we want to defend our clients' rights and whoever we are representing, but we're hoping that it makes a bigger impact so everyone benefits, so that everyone gets the same freedoms that we might win for this one person. So as Danny mentioned, we're 15 years old, and so some of the classic cases in the past that we've been involved with actually mostly involved the Department of Justice, and we're sort of constantly battling them on various fronts, as now Google is as well. But the earliest one was actually a case called Steve Jackson Games, and that was sort of how EFF became sort of founded. Was that the Secret Service had raided Steve Jackson Games because they were hosting a bulletin board system, and they claimed that some of the documents that were posted on the system were a national security threat. And they just came and grabbed all the computers without a warrant, without anything, and just said, well, no one has any privacy interests in this because it's a bulletin board, and plus there are private mail accounts on there, but it's on someone else's computer, it's not in your house, and therefore you have no Fourth Amendment rights to protect yourself. The traditional line had been, well, things in your home or in your possession you have a Fourth Amendment privacy right for, but if you, say, have email stored on someone else's server, well, then no, you don't. And so EFF jumped in and fought the case and won to say that you do have privacy interests in things like your email, in your private communications, whether they be electronic or paper, whether it's in your actual home or somewhere else. And that, it's hard to believe now in this day and age, I think that was actually an issue. But at the time, a lot of the judges and other legal advocates were like, well, who cares about this electronic stuff, right? It's only the paper stuff we care about. It was back in 1990. Other cases we were involved with were the initial attempts by Congress to ban obscene or indecent material on the internet, the Communications Decency Act, and the Child Online Protection Act, which is still going on, which for any of you who've been following the subpoena to Google for the search results, that is actually related back to the COPA case, the Child Online Protection Act case. But EFF has been part of those cases from the beginning to challenge people's First Amendment rights for adults to be able to not only publish but also witness other speech which some people somewhere might consider indecent, that the First Amendment has a pretty broad protection and that it's only in the narrowest of circumstances that the government should be able to regulate any of that. And one of the most important parts of that is that we helped with the ACLU and a bunch of other organizations put forward this theory that perhaps technology could be a solution instead of law. Rather than having government and legal regulation of online content, things like filtering, things like customization could be perhaps another tool. Those things aren't perfect, and there are lots of problems with them as well, but looking at technology as an alternative to government regulation was an important aspect. And then finally, one of the other battles we were involved with was around encryption regulations, that the government had tried to impose restrictions on the exportation, which is sort of an odd term when you think about global networks, but the exportation of strong encryption. And we came in and sort of brought this First Amendment argument saying, well, you know what, actually, encryption, when you teach it, when you talk about it, it's education, it's speech, right? It's how people learn, it's human knowledge, right? On some level, the implementation of the code might be different, but the code itself is a form of speech when you're showing people your source code or when you're talking about pseudocode or algorithms or things like that. And we were actually the first people to convince a court that code is speech. And that in order for the government to be able to restrict code and restrict the sharing of information and knowledge, they had to pass the strict scrutiny First Amendment test, which keeps the government's interests very, very narrow and doesn't allow them to regulate a lot of this kind of thing, this kind of speech and expression. So that's a little bit about EFF in the past and some of the early cases that helped sort of form our legal basis. This is kind of where we are now. Some of you may have heard about some of these things. In fact, there was a talk here, I guess, about the Sony rootkit litigation, so I won't go into too much detail on that, but some of you may have heard Sony surreptitiously slipped onto their normal music CDs, the things they just sold in stores, a set of software programs, depending on which CD you bought, that would install itself on your computer and, in fact, cloak itself in ways that are similar to how rootkits cloak themselves, so that you couldn't find it, remove it. It became almost impossible to get rid of. We ended up suing them over it, and actually have now entered into a preliminary settlement, which the details are getting worked out on. But one of the things that we were actually pretty proud of was that we had actually sent Sony a letter. One of the things we try and do is be really upfront with people. Before we sued, we sent them a letter and said, look, this is wrong. You shouldn't be treating your customers like criminals. You shouldn't be slipping the software on there, create security vulnerabilities. You should take these steps. I can't remember how many we listed, but like 7 or 8 steps to fix the problem. And they didn't. And so then we went and sued them, but we tried to at least give them a chance, right? We tried to sort of follow in some ways the security vulnerability protocol, which is you alert them, you give them a chance to fix it, and then you have to go public and you have to do what you have to do. And the settlement actually, if you go on EFF's site, you'll see more information about it. We think actually does pretty much achieve most of what we were asking them to do. All the music that was encoded in DRM and stuck inside of this malware has in fact is going to be offered to every single customer as a free unencoded, unencrypted MP3 that you can download, and you can do whatever you want to, what you would normally get if you just ripped a CD. There's compensation for people who have had their computers affected, and most importantly, Sony has actually killed both of their current music DRM programs. They are no longer producing those CDs, and they have no plans for the current future to produce those CDs. So we got them to actually stop those two programs in their tracks, which was also pretty exciting. Some of you may have also seen that we sued AT&T, and there's been a lot of kind of press around this lately. This is related to the NSA wiretapping. And one of the things here, and one of the reasons that we brought this lawsuit, is that a lot of the NSA warrantless wiretapping, where they aren't even going to the secret court where they can get warrants, and they aren't going for any judge, which is what the Constitution requires, they've been tapping phone calls and emails. In addition to specifically targeted people, they've actually also accessed AT&T's database of all of its call logs. They've actually, AT&T has been working with and cooperating with the NSA to let the NSA kind of data mine many, like I think it's over 300 terabytes of data in these databases to sort of sift through. And this is not for suspected terrorists that they know ahead of time. This is for looking for keywords, looking for other things where they might be able to put together a profile. So it's not as if they already have someone in mind. This is a real phishing expedition. And one of the key things that we think we can bring to the table is a lot of people hear about NSA wiretaps and they go, that's wrong, but getting into how does it actually work? Who's actually helping them? What technologies are they using? And figuring out, well, maybe one of the choke points here is that they are legally accessing someone else's database and data mining. And so if they are violating our constitutional rights, maybe if we bring a lawsuit to force a judge to order AT&T to stop helping the NSA, maybe it will actually slow down or maybe even kill the program. So one of the things we do here is not that we want to bankrupt AT&T or anything like that, but what we want to do is get AT&T to stop through a court order if they won't stop already assisting in the constitutional violations of our privacy rights. So that's part of what we brought in that suit. The third thing is the patent busting project. It's actually something that we started a little over a year ago. As all you know, software patents have their troubles, and one of the big issues that we've seen come about actually is not only are companies like Google and even Microsoft and everyone else getting sued by so-called patent trolls, but actually that there are some patent owners who are shaking down universities, nonprofits, and even small businesses, mom and pop businesses. And it's really sort of odd that they get these patent infringement letters, but they're starting to go out. So a company called test.com claims to have a patent literally on the method of testing online. Someone writes a test, someone puts it up on a website, people take it, they pay money for it, and then the fees get split between the person who wrote it and hosted it. They got a patent from the US Patent Office on that. So they sent a threat letter to over 400 universities saying, any of you who are running distance learning programs where people might be taking exams online and you charge tuition or a per class rate, you owe us a fee and you have to pay a patent license or we're going to sue you for patent infringement for educating people. So this is again something that EFF felt was sort of a violation of our fundamental rights and a misuse of the law, and so it's something we've gotten involved with there. So what we did actually this is for the patent busting project is there's so many bad patents out there, we kind of held a contest and picked our top 10 worst ones. So if you go to the site, you can see them, but this is sort of some of the people we're targeting and some of the technologies there, but it's on the site. So I'm just going to finish up a little bit, and then we'll take some questions. These are sort of some of our ideas for what might be coming down the pike. What are some of the next generation of tech lawsuits which EFF might get involved with? What sort of things to think about? Obviously, you all here have excellent lawyers, and I'm sure they're constantly berating you about what you're thinking about and telling you can't do fun things that you really wish you could do. But okay, so one of the things that I saw recently, we'll start on the upper left with Dave Weiner. Hi, Dave. Is that he actually has been somewhat concerned about people's use of his blog and about the use of RSS and things like this, not from a stance of not crediting him for the things that he's done, but more from the sense of what can other people do with your content when they take it off your site, right? And this is obviously something of interest to Google, right? What can you do with people's content when you've indexed it or copied it for a purpose of allowing people to learn about it, right? And so there's actually sort of a spat going on with a website called Top 10 Sources about whether it was copyright infringement for them to aggregate people's RSS feeds and say, okay, these are the sort of top 10 sites in this area, you know, top 10 travel vacation sites or something, and whether or not that should be a copyright violation if they republish it on their own site. And so this is not an actual lawsuit, but I think you will see a lawsuit in the next 2 years about feeds and aggregation. I think someone's going to bring one, and there's going to be this real question as to is it a copyright violation for people to take information that's already free on the web somewhere else and aggregate it in a useful place. So we'll take questions after I finish. And so, yeah, like I said, this might have some connection for those of you here at Google. The other thing is Wikipedia. This is actually from a website, wikipediaclassaction.org, which, as far as I can tell, is just one person who is really pissed off. But they, you know, they, of course, it's interesting. They took the Wikipedia graphic, which I'm sure is Creative Commons or something, but you know, and sort of morphed it into this thing. But basically, it's a gripe site to complain about anything that anyone has ever put on Wikipedia that is ever inaccurate about anyone in the world ever, right? And they want to file. They're looking for a lawyer, and I don't think they can find one because I don't think it's a very good case right now. But they're looking for a lawyer to file a massive class action lawsuit against Wikipedia on behalf of everyone who's ever been disparaged in any article with any wrong information ever on Wikipedia. So needless to say, we think this would be a big disaster if it ever came. And we don't, I mean, we think Wikipedia has some good defenses, and we'd obviously want to help defend them. But this is something to think about, again, the sort of aggregation of data or, you know, sort of user involvement in your data, right? And what problems can it cause? And I think there's going to be some cases coming down the pike in the next 2-3 years that are really going to address what responsibility the website has, or the host, or anyone who even helps administer, versus the users when things are very malleable. The more malleable that online content becomes, the quicker it can change, the more it can react to any particular user or stimuli, the more those legal issues are going to arise. And then finally, in the lower right-hand corner, I don't know how many of you are familiar with a game called City of Heroes. It's a massive multiplayer online game where you get to be a superhero or a supervillain, and you're in some place called Paragon City, and you fly around, and you can, you know, form guilds, much like World of Warcraft kind of thing. Marvel actually had brought a suit against the makers of City of Heroes and the people who ran the service, not the end users, because they kept noticing that a lot of users were creating Marvel characters, Captain America, the Hulk, Wolverine, various other people, and they, even though the service killed the accounts once they were notified, the Marvel still claimed that the service, City of Heroes, I think it was NCSoft was the company, was responsible and in fact should start paying even if they weren't aware of it, even if they didn't know people were creating it, or they should change their character engine so that people were prohibited from creating these kinds of characters. Now that case actually ended up settling, so we didn't get any established law on what happened, but I think again you're going to see more of this kind of thing around what are users doing with your technology and how responsible are you as a company, and it's something that we're very concerned with because the environment and the climate for innovation, for really interesting things to happen as far as the EFF is concerned, needs to be pretty open. You need to have a lot of experimentation, a lot of different takes on it, and if you start holding every single company liable for every single thing their users ever did, that doesn't scale, right? You know, you're gonna, unless you're a massive company with lots of insurance and lots of lawyers willing to go to the mat on every single issue, you're gonna get a lot of people who aren't willing to do much of anything unless they get 1 million licenses from 1 million lawyers. Okay, I think that's, so.
Such a plaintive kind of cry for help. I mean, we'll probably just go for questions here, but a lot of people do ask how they can help, and of course the main one is become a member. Supporters and funders. We get almost all of our funding. Oops. Do you want to mention the t-shirts and hats? Yes, yeah. If you become a member now, we can give you the hats and t-shirts that we'd usually send you, and so you know it's instant gratification. It's like an impulse charity gift. The other side of this is give us feedback. Is let us know what you think. About any of the issues, about anything you see coming up. It's genuinely revealing to us, and this is true about, you know, oh, I think that something should be done to stop this, but how often the lead we get on being able to prepare our issues comes from somebody who's working on an interesting technology in their spare time, or has read a paper on a cryptographic approach or something like that, who's just thinking in terms of how this is going to affect the world, and will email us and say, look, have you considered what this is going to do? And you know, trusted computing is an excellent example of that. You know, it really helped us to have people come to us and say, okay, this is something that's clearly going to transform digital rights management and even the sort of ownership and reification of data. And we had enough time to sit down and work it through and not just come with some sort of knee-jerk response, but actually come up with some positive suggestions about how this could be used for good or awesome. So that's one of them. We're small enough to listen. This is a genuine open invite that we give out, which is that if any of our members are in the San Francisco area, by all means come over and get a tour of the office. This is just funny. Let me see this. I hope I won't get thrown out for using A9, but you'll see why in a sec. So this is A9's thing where they go around and have little view of different buildings. Oops. This is the EFF offices, or slightly down from it. And if I just go down here a little bit, what you can see is that I'm sure you know about this. That this is they drive around in a big van monitoring everyone. They're Amazon. They're much worse than you, honest. I can't get this picture, unfortunately, but there's a lovely picture of the EFF offices with our attorney in charge of privacy outside having a cigarette. And you know, he's sitting there going, like, you know, I'm not paranoid. He's on the NSA case now, so I don't know what's going to happen to him. We do need to stay 2 years ahead. You can also become a major supporter. Our definition of major is probably smaller than most people. It's generally over $1,000. You suddenly become our best friend ever. We're not like a lot of organizations. If you are a member, you'll know that we don't besiege you with emails or sell the mailing list, for obvious reasons. It's amazing how many people approach you as a non-charitable organization saying, we have this great way where you can build your membership. We'll sell you these people's names in return for you giving private information and these little web bugs. They're great too. And we're going to have to sue you. So we don't do any of that. So we're very quiet, but two things that we do, we take shares. That may be of interest in this context. We do take share donations. We're also working on an endowment fund, which is, at the moment, we do kind of live off the crumbs thrown to us by our members, but we really want to build up a bit of stability for that, because what we can do varies depending on, you know, how comfortable our members feel. So if, for instance, the bottom falls out of the stock market, we have problems, and that's not the case of the people that we generally fight. So we're working on building an endowment. We have, I believe, $1 million in it already. We have a promise for $2 million if we raise another $1 million. So if you'd like to, I mean, not that I expect you to write a check now or anything, but if you're interested in working with us on that, we're very interested in building up a fund that will keep us going for the next 15 years. That, I think, is the general talk, so we'll just do the Q&A now. Oh, okay.
I just want to add that also Google has a matching program that some of you might know about when you give to nonprofits, and it does apply as well to EFF. So if you give, it gets, I think, matched 1-for-1. Oh, it is?
You're not meeting their call, whatever stupid call.
Huh.
I think it's a Patriot Act.
Yeah.
Because our donations show up, and basically it's really going to get
Oh, that's interesting. Well, it was for a while. We'll check on that. So then you should have to give double, basically, to make up for it, right? But one thing I also wanted to say, just you know, to give some context too, is it doesn't. You'd be surprised at how little money it actually takes to make a big difference in a lot of this stuff. You know, and not that like $1,000 is a little bit of money, but compared to, I mean, so the RAA last year spent $16.9 million on litigation alone. Like that's That was just for lawsuits and things like that. And you can tell from the numbers you saw in our budget that we have obviously a lot smaller budget that's not all going to litigation, that's not all going to issues dealing even with copyright and online stuff. So, you know, if you're at all interested and concerned about where your money's going, we can talk to you about that. And also, you know, that we think a lot about how to make the most effective change. So, yeah, now we'll just take questions here.
It would seem that some of the things that you cited would be relatively settled in terms of reproducing somebody's RSS feed, how would the newspapers that said you can't take my article into your frame already won that issue in terms of stuff on a shared game. Can't the game sharing company take the position that we're a service provider? You tell us it's violating your copyright, we take it off and we're done.
So the question for those who could hear is, haven't a bunch of these issues already been decided? Surprisingly, no, because really what ends up deciding it is having a published court decision. There'll be a lot of settlements, cases will be dropped, but you will be surprised how many people, like a case will settle and 10 more will pop up claiming the same thing. You really do need to have a court ruling, and it is surprising on how few court rulings there are. There haven't really been enough to establish a precedent on any of these issues. Yeah, but it's a law that passed by Congress that has to be interpreted. And in the Marvel versus NCSoft case, you know, NCSoft, City of Heroes, did defend, saying that we are qualifying as a service provider. And Marvel said, no, we don't believe you. We're going to litigate this case and wait for a judge to make a ruling. And they didn't get that far, but they were spending hundreds of thousands of dollars on the case thinking they were going to win.
So this is something that I was going to bring up, but which is that we don't actually just pursue cases and represent people. We also often give amicus postings to other cases. And that's specifically because we often be in the case where it really doesn't, the decision that the judge makes is fairly clear-cut, that they're going to support one side or other, but the legal theory on which they judge that is very important. So, for instance, if they decide to judge a hacking case on grounds that it's trespass, that, I mean, this is me speaking not as a lawyer now, so there are various people in the legal department just going, no! But as a hypothetical example there, you don't want that decision made like that because that will set a precedent that will go on and other people will use that in that way. It may be that that case could be won and exactly the same decision happen, but on a different legal theory. And we're entirely happy to do that. For instance, we often file amicuses about anonymity cases online, where somebody's subpoenaing an ISP in order to enter find the identities. It's very easy for a judge, if he's not or she is not appraised of the sizable case law that argues that the anonymity is an important right, to just make a decision that these people should have their names revealed. And that's very dangerous, of course, because that's a precedent that can be used in future cases. So a lot of the time, it's suggesting legal theories to judges that they might like to use. And that really, really helps in making the law match what we think is a reasonable way the world should work.
You mentioned earlier electronic voting, and one of the problems I've seen or worried about is, suppose that you pass laws that says everyone, if you're using a touchscreen voting machine, there has to be a voter verifiable paper receipt so that you know that the machine recorded your vote. What good is that if the law doesn't say anything about what the legal record of the election then is? And all those lovely paper receipts go into a dumpster, and if there's a recount, they just go back to the electronic copies and never touch them.
Oh, there was actually specifically a case in California recently where that was the law that we were trying to fight, which would basically dismantle those two things and say that wasn't going to be the. Well, in fact, the law was that a specific law was passed that said this is the legal record, and there was a real danger that it was going to be vetoed by Mr. Schwarzenegger. And it was actually a really good success because generally speaking, if your Secretary of State says veto a piece of legislation, and you don't have particular input on it, you'll yeah, okay, fair enough, you're the expert. And also the voting officials didn't want this law to pass because, oh my God, we're going to have to count all these votes. It will take so long. So they were arguing against it for an efficiency point of view. And we managed to marshal an awful lot of people to contact the governor directly, and he didn't veto it. They passed into law for exactly that reason. So California does have that connection now. So it's a really good point.
And outside California?
Case by case. We've just, Matt Zimmerman, who is our e-voting attorney, has just gone and had a really, it's worth looking on Deep Links, which is our blog site, had an adventure in North Carolina where Diebold went to court. Basically, North Carolina has an excellent e-voting law that says you actually have to escrow all your source code and libraries, and Diebold went to court because they run on Windows CE, and so they can't do that. And said, we can't do this. And the court said, oh, okay, well, you don't have to do that. It's okay. You can have your stuff registered. And we sent Matt down. Matt fought the case, won, so they did have to do it. Then they got certified anyway, and then so Matt went back to North Carolina and fought that case again, and eventually they were excluded from the certification process. So you really do have to do these things on a fight-by-fight basis. But there are good e-voting laws popping up everywhere.
Yeah, but I should say that the end result was that Diebold is pulled out of North Carolina and is not even trying to sell machines there anymore. The other e-voting companies actually did agree to the escrow. At least one of them did. And so, you know, it is a state-by-state basis. That's how election law is done. We're also in Ohio, Florida, and Nevada, and a bunch of other states. But it's really Illinois as well. It's really, I mean, part of the thing also about trying to do a national project or a worldwide project, but being based in one place, which is San Francisco, is we always need allies on the ground in the place we're working. And so oftentimes what we'll work on is when people come to us or we can reach out to them and work together on something. So we kind of pick and choose our battles that way. But ideally, yes, we would love, and we've supported a federal law to standardize all this from the beginning. Yeah, right there.
RIA, copyright, protection stuff. I understand why you don't want technology to be in place that can lock down information, media, et cetera, forever. But the recording industry does kind of have a legitimate concern about stuff getting pirated. Do you guys have any suggestions about
I'm glad you asked that question. Yeah, so what's our solution to RAA, file sharing, copyright, all this? We have a white paper on our site. If you just search EFF, A Better Way Forward, or EFF VCL, there's a voluntary collective licensing program that we actually think would work much better than any lawsuits, than any of the kind of draconian legislation that's being put forward by trying to run the technological middle people out of business. It works very similar actually to the way in which radio stations license. It works very similar to the way in which cable, satellite, webcasting license. I mean, there are problems with these systems, but as an alternative to what's happening right now, we think it's a really good solution. So it's a sort of two-page white paper that pretty much lays out exactly what we think a good alternative would be. Let me make clear too, from EFF's perspective, whether it be patent, copyright, trademark, whatever on the IP side, we are not anti any of those things per se at all. We actually are just trying to bring a balance to it. We want there to be fair use rights. We want there to be consumer rights. And I guess we feel that most of the battles end up being where the maximalist position comes in trying to grab everything, and we end up usually being on the other side. People who come in and have a balanced approach, we typically don't oppose them because they're balanced already. So, I mean, so we end up being on the other side, but I just want to emphasize we're not against these kinds of systems. We just think they need to be reasonable.
I mean, I think a good example, and I'm not speaking kind of ex cathedra for the EFF here, but I think, for instance, you know, a lot of times people will say, you know, that you're fiercely against DRM, and the reason why we spend a lot of time criticizing DRM is not because of the idea of DRM itself so often, as the fact that it's backed by the DMCA, which means that that effectively criminalizes any circumvention, even if it was for legitimate use. So you end up being in this situation where the kind of debate that we'd want to have, which is, what is good DRM? What would be a system by which you could build up a system by which artists could be supported and we could still have these freedoms to use fair use, has already been constricted because if DRM is present, we won't have those fair use rights that we've traditionally had. So we end up, as you say, we end up finding these things often in a maximalist core, which ends up making us look as though we don't have positive things to say, but that's because we've got to critique these ones that are already being put forward.
Would you ever consider or be able to push for criminal charges to go against AT&T executives for wiretapping?
Wow, criminal charges against AT&T executives. I'm probably going to have to pass a little on that one, partially in some sense because we don't know the full extent, right? Like this is just the beginning of figuring out how extensive it's gone, you know, I don't know. As a sort of civil rights lawyer, I hate to actually think about putting anyone in jail in some ways, but I certainly think that accountability is there, right? I mean, if anything, it's like I said, we don't want to put AT&T out of business. We just want to hold them accountable and make them stop. And, you know, and hopefully the shareholders will see that also as well and say, you know, and the executives will see that. And, I mean, our number one thing is we want the program to stop. We want people's rights to stop. I mean, they're violating them today. Right now, as we speak, this program is still going on. And so I think once we achieve that number one goal of stopping the program, then we can sort out sort of what accountability means. But I think a lot of that's going to also depend on what we learn. You know, as more hearings happen in Congress and more evidence comes out. So.
Do you think it would help the fear in executives 20 years down the line?
Sure. I mean, well, yeah. I mean, any time serious criminal penalties can be brought against someone, it's going to be a deterrent. But I don't know. I have a little. I personally I'm a little cautious about that. But I mean, again, I think it depends on how culpable people are and what the result's been. But I would like to see AT&T and their executives deterred. Definitely.
So with the Sony case, is there going to be any further litigation?
Can you speak up a little bit?
With the Sony case, is there going to be any further litigation? Is there going to be any punitive damages, basically? What they do is pretty reprehensible.
Right, so the Sony case, are there going to be any punitive damages? There will be a pretty sizable fine against Sony that's mostly going to actually get distributed to people. So you will be getting, so if I buy one CD, I don't remember the exact formula, but if I buy one CD, I will not only get free MP3s of all the music for free that I bought, but I will also get, I think on some level, some compensation in addition. And if you times that by the number of people they sold the CDs to, it ends up in the millions. So there will be a fine in that sense going directly back to the customers that will impose it. Part of what happened.
How about a fine election notice like $1 billion?
Well, okay, so why not try and bankrupt Sony? Why not go for $1 billion? This is actually, so this is a secret of the EFF. When you're in litigation, right, you're always making these kind of weird judgment calls, right? One of the things is that Sony basically came to the table and was willing to settle quickly and basically caved to almost all the demands in our letter, but probably not for $1 billion, right? And I can't disclose some of the details of the talks necessarily, but so there's this question of, yeah, we could go for the gusto, right? Try and spend 3 years in court and a lot of our members' money trying to get this sort of gold brass ring, you know, golden egg that would really, really, really stick it to them. Or
the head of Sony Entertainment.
Right, you know, Andy Lack's head on a platter, right? Or you can say, well, you know what, we get 90% of what we really wanted for people, which is their music, without all this crap on it, plus some money, plus some penalties, plus Sony agreeing not to do this all up front in a very quick and powerful way. It's always a judgment call, and so it's not that you know, on some level I wouldn't have liked to maybe had a bigger stick, but I mean, when you're representing clients too, like we represent people now, their interests are more important than ours, and they had strong feelings about it too, and so it's something that we struggle with. It definitely is, and I always wish we could get more, but we also felt like this really got to the core of it, which is the programs got killed, people got their music, and they do get some compensation. And quite honestly, from what we've heard, I can tell you the back channels of the people we know in the music industry is this has sent shockwaves. You know, that a lot of the companies that were like tempted to go in these waters have now backed off seriously because of the bad press and of the potential downside in terms of penalties and litigation.
It's also the attorney general.
Oh, yeah. I should mention that at least 4 state attorneys generals have also started an investigation based on this case. And those may still end up leading to even more penalties for Sony. I mean, we won't be directly involved in that, but we've certainly our cases, we've turned over the information from our case to them, and to the extent that they're going to push for more, I think you'll see some more coming out of it.
Does EFF collect any damages from the attorneys?
From the start.
Does EFF collect any financial compensation?
Oh, from lawsuits? Yeah, so when EFF files a lawsuit like this, there's an opportunity to get attorney's fees, which is basically when we do all of our cases, we don't charge any of our clients anything. It's all pro bono for free. But when we win, we sometimes can get our fees paid back by the other side. And so there is a portion of the settlement that will pay us back for compensating us for our time. And that's basically what we take. So we're getting a timeout symbol.
Should we take 2 more?
I mean, this may affect the video. I don't know if we should keep going.
About 5 minutes. Okay.
Way in the back there.
I'm wondering what the timeline is for the AT&T case. Is this going to take years to drag through the courts, or is there some introduction?
How long will the AT&T case take? That is a really good question. It's going to depend on a couple things. Obviously, we'd like it to go fast. But one is we don't know what AT&T's response is. The ball's in their court to come back and are they going to deny that there's any kind of program? Are they going to kind of justify it that it's legal? Are they going to claim that they can't talk about it for national security reasons? That's going to dictate how big a case this is and how tough it is for them to defend or us to win. The second thing is the government. We don't know what position, if the NSA and the DOJ are going to intervene and try and say something about the case or try and push the court in one direction or the other. The more they get involved, the more complex the case gets. So I wish I could tell you more, but at this point, it's actually kind of out of our hands as to how complex it gets. If it stays cabined in, there's an option for us to move quickly to have the court rule ahead of time, even before a trial, that this is illegal and they should stop. And that's something we're considering, but it'll depend kind of on how they respond. So it could be, or they could be like Sony and they could quickly settle, but I doubt it, right? That would be a dream. So I'd say realistically, you're looking at 6 months to 6 years, somewhere in there. Depends, unfortunately. Oh, now we are getting the timeout symbol. Okay, well, we'll be around, so if you have any questions, come on up. But thanks so much for coming out. And we have t-shirts and hats and stuff if you want to buy a t-shirt or hat. Thank you very much.